Good evening. The September 9th, 2021 meeting of the Santa Monica Rent Control Board is called to order. Would the secretary please take roll?
Yes. Commissioner Foster.
Here.
Commissioner Torosis.
Here.
Vice Chair Duran.
Here.
And Chair Sultan.
Here.
Commissioner Phyllis is absent and will not be joining us tonight.
Thank you. Okay. Anyone wishing to address the board on a specific item on tonight's agenda should have already contacted our board secretary prior to the meeting. We will recognize the speakers and arrange to have them speak when it is their turn in the queue. Moving on to approval of the minutes, may I have a motion to approve the minutes of the board's last meeting?
So moved.
I'll second.
Okay, great. Motion and a second. Secretary, would you please take a roll call vote?
Yes. Commissioner Torosis.
I'm going to abstain since I was not at the last meeting.
Commissioner Foster.
Yes.
Vice Chair Duran.
You're on mute, Steve.
Steve.
Point of clarification, I also wasn't there, so I don't know whether I can vote to approve or not.
I don't think this has ever happened.
Sorry, Mr. Davis, just a moment.
You can vote. You don't have to abstain, but if you're more comfortable abstaining, you can do that as well.
Okay. Well, then that presents a problem. If we don't have a majority then tonight, well, are they put off for the next meeting?
Yes, we could bring them back for the next meeting.
Okay.
I mean, would it make you more comfortable if I said I approve them? I mean, I did review them. I just wasn't there.
I would only offer that it was an incredibly short agenda and not terribly complex in material.
I see that.
But certainly no pressure. We could always bring it back.
Right. Well, that being said, I will still, I think since I wasn't there, I can't verify whether they're accurate or not. So I will have to abstain.
All right, and Chair Sultan.
Yes, I approve the minutes. Last meeting.
So Commissioner Torosis, did you change your vote or are you abstaining as well?
I'll vote to approve the minutes.
All right, so then they are approved. Thank you.
I'm sorry, motion carries.
Moving on to special agenda items. Do we have any brief announcements, commendations, awards, or introduction of special guests?
Yes, I have an announcement this evening, the announcement that I've been making for several months, which is that both the city and state eviction moratoria are scheduled to expire at the end of this month, at the end of September. Under the city's emergency orders, tenants will have a year to pay any unpaid rent due to the impacts of COVID-19. The good news is that the state does have $7 billion in funding available to assist low and moderate income tenants to pay their rent. Both landlords and tenants can apply for that assistance. The board voted last month to work collaboratively with the city to ensure that Santa Monica landlords and tenants are aware of the housing funding that's available. So the way to access that is by housingiskey.com or to call the phone number 833-430-2122. And I looked this afternoon, and as of this afternoon, there have been approximately 780 Santa Monica households who have been assisted with unpaid rent. The average assistance per household has been about $17,000, and Santa Monica has received about $13 million out of this funding that's available. But there's a lot of funding still available, so I encourage landlords and tenants to apply for that. And then I'll also just mention that since we last met, as of September 1st, the annual rent increase went into effect. That was 1.7% or a maximum of $39. That's all I have this evening.
Can I add something, Chair?
Yes, please.
Yeah, and Tracy, thank you so much for that announcement. And as a reminder, just to reiterate, the city, the rent board staff, and local organizations are available to assist tenants with those applications. And quite a few volunteers, including some of us on this board and the staff, will be there on Wednesdays. If people make appointments, so I think it needs to be reiterated that they do need to make an appointment, and someone will be there to help them on Wednesday evenings especially.
And I believe the way to make an appointment is to call 311.
That's
Is that
right.
correct? Okay.
Yes, that's right.
And
I
I
believe.
do.
Oh,
Sorry.
sorry. I was going to say I believe some walk-ins will be accepted, but the preferred way to attend is through making an appointment at 311. Yes, Commissioner Terosas.
I just wanted to make sure that we reiterate the language access piece, that this service will be available in Spanish, and I'm sure if there are individuals who need other languages, we could make those arrangements. So we want to make sure that language access does not preclude anyone. Of course, I'm making that announcement in English. I hope we are doing outreach in multiple languages, but that's pretty important to me, so thanks.
Yes, yeah, the city's outreach is going out in multiple languages. Every household should have received the first postcard, which is in 4 languages. And yes, assistance will also be available in multiple languages. Thank you.
Thank you so much. Okay, now is the time set aside for public comment, but I don't believe we have. Do we have any public comment on matters that are not included on the agenda?
No, there were no requests to speak.
Okay, great. Thank you. Okay, moving on to jurisdictional items. We have items U0, so this is 10A, U0104 to U0127 regarding the property at 220 San Vicente Boulevard. The appellant is San Vicente Tower SPE LLC, the owner. May we have a staff report, please?
Good evening, Commissioners. Before I begin my staff report, you have to vote whether to accept a late filed appeal from tenant Paula Wylot. Ms. Wylot submitted her appeal through her attorney, Denise McGranahan, 1 week after the appeal deadline. Her attorney states that she has multiple disabilities which preclude her from using the computer or telephone to communicate, and instead she mails her attorney notes. And here she was very ill and couldn't get out of bed for days, and as a result was unable to communicate in a timely fashion with her attorney to ask her to file an appeal on time. Given her disabilities and health condition at the time, staff recommends that the board find that there is good cause to accept her late appeal.
So moved. Absolutely.
I second that.
Second. Sorry, I believe Chair Sultan seconded that.
Can we take a vote?
Yes. Commissioner Torosis,
Yes.
Commissioner Foster,
Yes.
Vice Chair Duran,
Yes.
and Chair Sultan.
Yes.
Motion carries.
Thank you for that.
Thank you, Commissioners. After San Vicente Tower SPE LLC bought this 90-unit apartment building at 220 San Vicente in June 2015, it embarked on multiple construction projects to repair deferred maintenance and to upgrade vacant units in common areas to garner higher market rents. Tenants in 24 units filed construction decrease petitions between March and June of 2018. 7 of those petitions were withdrawn or dismissed, almost all because the tenants moved away. After reviewing the record, the hearing officer granted rent decreases in the remaining petitions that will on average allow the tenants to not pay rent for 2 years. Both the owner and 10 of the tenant households have appealed the decision. The staff report and the supplemental staff report address the numerous arguments raised in both appeals. I will highlight several of those issues in my oral presentation and can answer the board's question as to any other. The board reviews this matter as an appellate body and should overturn the hearing officer's findings only if the appellants show clear error in her decision. Therefore, the board should affirm the hearing officer's findings if they are reasonably supported by the record, even if the board would have decided the matter differently had it been the finder of fact. And the appellants bear the burden of showing that the hearing officer clearly erred. In their appeals, the appellants argue that the hearing officer's decision to grant a decrease from the owner's perspective or deny a decrease from the tenants is not supported by the evidence. But it's not sufficient to point to a piece of evidence and argue that the hearing officer should have weighed that evidence differently in making a finding. The hearing officer has to review the totality of the evidence in the matter, and so long as she made a determination that is reasonable, given that totality of evidence, her determination should be affirmed. The example I will highlight concerns asbestos abatement and the notification requirements involved in removal of hazardous materials. Because of the age and materials used in the building, particularly the ceiling composition in units and hallways, repairs and renovations in this property raise concerns about proper asbestos removal. What the record showed is that the owner hired qualified contractors and a third-party asbestos consultant to undertake the repairs, complied with requirements to notify AQMD, and complied with their inspections and requests. There is no record of AQMD citing the owner for improper removal of asbestos even after responding to multiple complaints. What the owner did fail to do, however, is notify the tenants of asbestos testing results as required by the law and its own asbestos abatement plan. Given that record, the hearing officer denied a rent decrease for improper asbestos removal, but she did grant a rent decrease for the owner's failure to notify the tenants of asbestos testing results as evidence of inadequate construction management. The cumulative pattern of inadequate construction management, which also involved the filing of inaccurate means and methods plans and failure to schedule construction meetings with tenants as required by the MMPs, reflected a lack of transparency about information to which tenants were entitled by law. Both the decision to deny and grant decreases regarding asbestos removal are reasonable given the totality of the evidence, and staff therefore recommends that the board should affirm both. Distinct from factual arguments raised by the parties is a legal one raised by the tenants involving the board's construction decrease regulation. All but one of the tenants' appellants argue that they are entitled to decreases for impacts from necessary repairs even when done in a reasonable amount of time and in a reasonable manner because of prong C of the board's applicable regulation for construction impacts. The reference impacts were primarily noise from necessary repairs to the foundation in the garage and the adjacent pool and walkways, and the repairs to the elevator, laundry room, and the balcony railing. If the construction is for a necessary repair, and the construction occurring on the property causes habitability violations or nuisance in the unit, which is prong A of the regulation, or substantially reduces housing services, prong B of the regulation, the board may not grant decreases if the necessary repair was done in a reasonable manner and in a reasonable amount of time. But under prong C, the tenants are entitled to a decrease if a construction impact substantially interferes with the tenant's ability to occupy the unit as a residence. The key distinction between the first two prongs and prong C, is the former are for construction occurring elsewhere on the property that impacts the unit, whereas the latter is for construction that no longer allows the tenant to live in the unit. When the board was adopting the construction decrease regulation, the Court of Appeals had issued its decision in Golden Gateway Center versus San Francisco Rent Board, and the board modified its regulation as it was adopting it to conform to the case's holding. In that case, a landlord had undertaken necessary repairs to the balconies of each apartment in the building. The tenants not only lost the use of their balconies, but they suffered from fumes from the construction, no longer had ventilation in their unit from opening the sliding doors through the balconies, and suffered other impacts from construction occurring literally outside of their units. These impacts, however, did not preclude the tenants from living in their units. The court, therefore, denied them a rent decrease because the repairs were necessary. Here, too, noise from repairs substantially impacted tenants in their units. The noise, however, did not substantially interfere with their ability to reside in their units. Code enforcement never, for example, ordered the owner to relocate the tenants because the level of the noise from jackhammers used to repair the foundation or noise from the repair to the elevator rose to such a level that the tenants could not be allowed to stay in the unit. Prong C of the regulation does not provide a basis for decreases denied by the hearing officer in this matter. As set out by the staff report in detail, the preponderance of the evidence in this record reasonably supports both the decreases granted by the hearing officer and those denied in accordance with the board's regulations and applicable case law. Staff therefore recommends that the board affirm the hearing officer's decision and its findings of fact and conclusions of law.
Naomi, you're muted.
Thank you, Haka.
Yes, thank you. Sorry. Are there any questions among the commissioners regarding the staff report? Yes, Commissioner Shrosis. Oh, no, I thought I saw a hand.
Sorry, no question.
No questions. Okay. Seeing none. Thank you. Okay. I believe we have multiple speakers on this item. So let us see if speakers are here and ready to share with us. The first speaker is Ed Chan, tenant appellate, and he has 10 minutes to speak. Is Mr. Chan available?
Yes, Mr. Chan is available. Mr. Chan, you excuse me, you have 10 minutes to speak. You have been unmuted. Please go ahead.
Good evening, Commissioners. Thank you for taking our time. Thank you for giving us the opportunity to have these rent reductions and also for giving us the opportunity to appeal. The first and most important thing that I would like to bring to your attention is page 18 of the decision, and it states Regulation 4400C, which is when rent decreases are authorized. So specifically, it says Regulation 4400C provides explicit requirements for and exceptions to the authorization of a rent decrease for construction impacts as follows. Number one, requirements. Board may grant a rent decrease under this regulation only under one or more of the following circumstances. A, the tenant petitioner's controlled unit is made uninhabitable by construction occurring on the property. B, construction results in the substantial reduction of the housing service. Or C, construction substantially interferes with the tenant petitioner's ability to occupy the controlled unit as a residence. Number two is exception. The board may not grant a rent decrease, and these are very important words, under subparagraphs A or B of the preceding paragraph or unavoidable construction impacts caused by necessary repair or maintenance, unless A, the construction is carried out in an unreasonable manner, or B, the construction takes a reasonably long time to complete. So the key takeaway for this is the exception only applies to when a unit is made uninhabitable and when there has been a substantial reduction of a housing service. The exception does not apply to when construction substantially interferes with a tenant petitioner's ability to occupy the controlled unit as a residence. Now, we understand that there was an enormous amount of documents and over 100 hours of testimony and 22 hearings, and there are 17 remaining tenants involved. But those few words under subparagraphs A or B of the preceding paragraph is vital to understanding what this regulation means and also how it should be applied. So unfortunately, the decision had the hearing officer had used this interpretation and missed those few words and applied this exception broadly to anything that the owner had done in terms of construction. And basically, if the work was necessary and the tenants had experienced noise or water shutoffs, then too bad. But if you interpret this correctly, when the construction substantially interferes with tenants living in their home, then we are entitled to a rent decrease. When there is so much noise that people cannot work at home, people cannot talk on the phone, they cannot talk in person, they cannot do video conferencing, when water is shut off, that people can't use their toilets, people can't wash their hands, people can't take a shower, people can't do other things, right? People, the noise, people can't sleep. People can't watch TV. People can't listen to music. These are all basic things that people do and common things that people do when they live in a home, that people do when they occupy a residence. This is substantial. And this has been occurring since 2015. Now, granted that the petition only covers the period of September 2015 through September of 2018, but there has still been construction going on up to presently in 2021. This has been 6 years of construction. This is not minor. This is not something that should be overlooked. This is substantial interference with tenants living in their homes, and we are entitled to a rent decrease for it. So the staff report had mixed up A and B. I'm sorry, they mixed up A and C of the requirements. So they said that A is when there's substantial interference from other parts of property to the tenant's ability to live in the unit. And then they said that C was when the unit was uninhabitable or precludes the tenants from living in their unit, which is not true. The opposite. A and C were reversed. They brought up the Golden Gateway Center case from San Francisco. And beginning in the fall of 1993, tenants began filing petitions with the board alleging that they had suffered decreases in housing services by virtue of the loss of full and enjoyment of their decks and ventilation without a corresponding reduction in rent, and asking the board for an appropriate rent reduction. Now, that is part B of our requirements, where construction results in a substantial reduction of the housing service. That is not when construction substantially interferes with the tenant's ability to live in their home. So, number one, that's a huge difference right there, right? They did not say that the unit substantially interfered with their ability to occupy their residence. It stated it stated they had a loss of service. But nonetheless, these loss of housing services, while tenants are in their home, is causing substantial interference. As tenants are not able to do the common things and necessary things that they need to do. Washing hands is necessary after somebody uses the bathroom. Flushing the toilet is a necessary thing when somebody is in their home, right? When people don't flush their toilet, that's what goes on in third world countries where they don't have plumbing. I want to move on to some other things. The 4400C, there's been three iterations of it over the years, and they basically all said that when tenants have substantial interference when they're using their occupied unit as a residence, that they're entitled to rent decreases. But I also wanted to bring up California Civil Code 1927, which basically gives all tenants an implied covenant of quiet adjournment. And quiet has been interpreted by the courts in terms of tenants as not only noise, but other things that interfere with them living in their apartments. So that also supports the Part C of Regulation 4400C1, where construction substantially interferes with a tenant petitioner's ability to occupy the controlled unit as a residence. So multiple issues that were denied by the hearing officer with regards to noise. There was the garage, there was the east walkway, there was the pool, there was the lobby, there was the laundry room, there was the railings outside that were done, and basically the hearing officer that said that all these projects were necessary and tenants had a burden of proof to show that it was either done in an unreasonable manner or took an unreasonable long time. And because tenants are not subject to the exception for C when there's substantial interference with the tenant's ability to occupy a controlled unit as a residence, there is no burden of proof. In the staff report, there was mention of asbestos, and that tenants had to prove the validity of a document from a code enforcement file that I had requested from Public Record Search. And I want to point out that the hearing officer had pulled a similar document on her own. It's Exhibit 93, Code Enforcement Public Records, and within those records, the pages vary with the report that I submitted, but it also shows a Santa Monica Code Enforcement officer issuing a stop work order for removal of asbestos. So I don't know how the staff report.
I'm sorry, Mr. Chan, that's been your 10 minutes.
I'd like to hear the rest of his thoughts briefly.
Sure. Yeah, Mr. Chan, if you can just, conclude briefly, that would be great. Thank you.
Mr. Chan, you've been unmuted. Please continue.
So I don't know how the hearing officer and the staff can say that there was no asbestos violation. The city code enforcement officer, Frank Cordova, issued a stop work order for asbestos removal. I'm not making this up. I didn't pull that file. Exhibit 93 was pulled by the hearing officer. All right, so there's no need to validate it because it came from her, from the Code Enforcement Division. And the other thing regarding that incident is it happened under prior management. So the core management group the core group had testified during these hearings, and they were the property manager while most of this construction was going on. However, when that incident occurred in October 2015, where there was asbestos being removed from the garage with no permit, that was still under the current owner. Current owner still had control. and the current owner should still be liable for what happened at that point.
Thank you. Thank you, Mr. Chan. I believe we have a question from one of the commissioners, Commissioner Terosas.
Yeah, I just want to clarify something with Haka and then maybe ask a question. The documents that Mr. Chan is referring to are the ones that you mentioned in page 22 and 3 of the staff report, correct, when you stated that the documents were not authenticated?
No, that's, I believe, another matter that was brought up by Mr. Chan in his response to the staff report, and which is referred to in the supplemental staff report.
Okay.
Regarding the October 2015 issue of the stop work order.
Got it. And the asbestos notice was that part of the record or offered for the truth of the matter?
When you mention asbestos record, Commissioner, what do you refer to?
So I believe Mr. Chan is saying that he has a record from the building officer that there's a stop work order because of asbestos. Is that correct?
Because the city's code enforcement department doesn't have jurisdiction over this, what they do is that they issue and there was a complaint about improper asbestos removal. Then we don't know exactly what, because there was never a testimony from any code enforcement officer about the specifics of this. But what we do have in the record, which is something that I referred to in the staff report, is the documents from HUMD itself, which responded to the complaint and came there and saw that HUMD had in fact been notified about the asbestos removal. The proper contractors and consultants were there, and the material was being moved correctly. And what is also in the record is that never did HUMD cite the owners for improper asbestos removal, but the hearing officer did give a decrease for other aspects of the asbestos issues that had to do with tenant notifications, as I mentioned in the staff report and the supplemental staff report.
Got it. And the owner, to my reading, did give a $10 rent reduction during the time that the laundry room was unavailable. Is that correct?
Right, that is my understanding.
Okay, thank you. That's that. I don't have any actual questions for Mr. Chan. I just wanted to clarify which section we were referring to here. Thanks.
Are there any questions for Mr. Chan? I'm not seeing any. Thank you so much, Mr. Chan. We appreciate your coming here, sharing your experience with us. The next speaker in our queue is Mr. Bill Davids, tenant appellant. Is Mr. Davids available?
Yes, Mr. Davids, you will have 3 minutes to address the board. You have been unmuted. Please go ahead.
Thank you. Thank you for the accommodation to speak. I wanted to go over a number of things very quickly, including the condenser issue. Basically, much was made in our hearing officer's decisions about construction management and building management's failure to communicate. One of the things that occurred over here was the fact that the condensers, the air conditioning condensers for apartments on the second and third floor, did not meet current building and safety standards in terms of energy efficiency. The original equipment from 1972 was removed. It was replaced by a second generation of equipment that did not meet building and safety standards because they were not energy efficient. This was during construction. They were removed. And then finally, a third generation of condensers were approved by building and safety because they met energy efficiency standards. The permits for that equipment were exclusively due to meeting energy efficiency standards. The permits did not cover anything else. We had on the second floor above the garage where the condensers hang, 11 out of 16 apartments warehoused, meaning that they were being prepared for renovation. The condensers were what I used to joke about equal opportunity noise. They were dispersed throughout the ceiling of the garage. A decision was made, and I have no idea who made the decision, but it was obviously to benefit the rental of the apartments on the second floor above the garage. to move many of the condensers away from the renovated apartments, and I wound up with a concentration of 8 condensers under my apartment. We're talking about industrial strength condensers. When a good number of them are running together, my apartment sounds like I'm living on top of the engine room of the Titanic. Basically, this is unbearable noise. It's 24/7. It's every hour of the day. We have tenants who are not green. They basically switch on their air conditioning in May, and they don't turn it off until November or December. I have to live with the noise because the people who are renting apartments across from me, down the hallway from me, are renting apartments for $4,000 or more. I am paying roughly 1/3 of that as an MAR. In fact, I'm one of the 2 lowest MARs in the building. I've been in the building for 31 years. I moved out here from New York, had a friend next door at one time who got me into the building. I am putting up with unbearable.
I'm sorry, Mr. Davids. That's been your 3 minutes.
Let's let Mr. Davids finish, please.
Yes, please.
Mr. Davids, you've been unmuted. Please continue.
Okay. Anyway, I've just been told I'm unmuted. Anyway, I have been living in this building for 31 years. I'm a long-term tenant, and the result of the renovations and reconstruction of apartments on my floor resulted in basically, if you go to part 1 of our hearing officer's decisions on page 14, it talks extensively about what a property nuisance is. On page 15, it talks extensively about the quiet enjoyment of one's land, one's apartment, and that essentially has been denied to me. I am living on melatonin and Unisom. I never used to have this. I'm only getting 4 or 5 hours worth of sleep, and it's specifically due to the concentration of condensers underneath my apartment, so they can rent the renovated apartments for literally triple what I'm paying, or maybe even more than triple what I'm paying. So this has been an ongoing concern. It has always been a property nuisance when the condensers were more evenly dispersed under the apartments on the 2nd floor. But now I wound up with a concentration of 8 condensers under my apartment, and it is making my life miserable, and it's certainly not providing me with the quiet enjoyment of my apartment. There are other issues that I want to go into. I don't know if you will extend time for me, or I'm not hearing that you won't extend time for me, so I will proceed. There is a problem in terms of ADA compliance with the building. They ripped out the front of the building. Basically, they did landscape work and hardscape work. This building is very difficult to get out of if you have a let's try this again. If you have a disability. I have an old leg injury that makes my leg very tired by the end of the afternoon. I had to, when they were having renovations over here, particularly in the garage was basically a construction maze. In order to get to the back elevator, when the front elevator was shut down for 61 weeks, I basically had to literally walk through all of the construction debris and construction equipment that was left in the garage. The hearing officer described the garage as a labyrinth. Basically, no one, when they were doing cosmetic work up front on the hardscape or landscape, no one gave any thought. I don't know if building and safety made any recommendations to them, but no one gave any thought to how people are supposed to get in and out of this building if they have a disability. There's an individual I know who lives on another floor whose disability has deteriorated over the last few years. And when he
Can I
tried,
interject for just 1 second? I'm sorry. I don't know if all of this information that's being described was in the filing, the paperwork that we're set to review, but so maybe someone can clear that up for me, because if it was not, then it would be
These issues
information that we can't see.
I believe these issues were raised on appeal. Haka, you can tell me if I'm wrong.
The issue of the issue that Mr. Davids raised was raised on appeal, and he has asked for a decrease based on the landlord's failure to make things accessible after they had done the construction, so that to provide new accessibility that didn't exist before while they were doing the construction.
Okay.
The ADA compliance is in here, Steve, if that's what you're asking.
Yeah.
Okay. I wanted to make sure, and I know the condenser issue was as well. Okay. Thank you.
Clear, there was no rent decrease granted for the condenser issue, right?
no rent decrease whatsoever for the condensers or for ADA access.
Can I ask staff a question quickly before we let Mr. Davids continue? Haka, is there anything, or Lynn, is there anything in the record concerning when a construction project reaches the level of surpassing the grandfathering of something like accessibility? ADA accessibility would seem to be one of the, penultimate items that we reduce grandfathering for, because people do have to be able to ingress and egress. Do you have any information on why, if a substantial change was made to that? And by the way, I don't know if everyone realizes this is a sub-sidewalk. It drops several feet, 6, 8 feet, 10 feet below the sidewalk, the entrance to this building. So, Haka, can you address that?
There was no evidence provided by the petitioners that said that the building department requires these types of ADA compliance issues or upgrades after a certain amount of work. There was simply no evidence of that in the record. There may be ADA compliance issues. There was no, but there was no one who provided testimony that the ADA in fact required these things, or that the issue is triggered after a certain amount of repairs or requirements. That was not in the record.
But such a complex issue, is that solely the responsibility of the petitioner to ferret out that sort of expertise of building and safety requirements?
Is that something that code enforcement is also supposed to address, or?
Correct. Code enforcement is the one who would cite the owner for failing to comply with the building code requirements. There was no evidence of citation on this issue.
So what you're saying is, because you're saying that within our jurisdiction, it's not an issue upon which we can grant a rent decrease because it was not a housing service that existed and was taken away.
That is exactly what I'm saying, Commissioner.
Thank you. Mr. Davids, I, for one, after 6 years of what you've endured, if you have parting thoughts, I'd like to hear them, for one, but we probably need to limit the quantity of time per our chair.
Yes, I appreciate your listening to these two grievances that I had. There were more grievances, including the overburdening of our water system. I'm not quite sure how you will allow me to proceed with that, but we had washers installed in the renovated apartments. This was indicated in record and also in my appeal. We had washers installed in the renovated apartments. This building has always had a fragile water system, a plumbing system. In fact, when the first management company that took over from the Sinke family, they hired a plumbing company called Mario's Plumbing, and I was speaking to one of the plumbers, and he told me that this building is a gold mine. So when there was a decision to get a permit to put in washers, no one thought about water capacity. No one thought about the amount of water that would be used in the half bathrooms in this building that were converted to laundry rooms. There was apparently within the hearing officer's rulings, there was an individual who testified that the water usage in a half bathroom is comparable to the water usage of a washer that was installed in these half bathrooms. The washers have washing and rinse cycles, and people don't use them just once during the course of the day. They use it very, very often. I know for a fact there was an instance described about a pipe rupturing in my bathroom. It also ruptured in the apartment next door, and that pipe led directly to the half bathroom where the washers are. This building has been overburdened with plumbing problems, and it was even more overburdened with the installation of the washers in the half bathrooms. Obviously, the half bathrooms aren't being used as half bathrooms anymore, but someone indicated that the amount of water in the half bathroom that was being used is comparable to the amount of water being used in a washer. And it makes absolutely no sense. I don't know how you extrapolate that, and there was no evidence on the part of the expert who testified. There was no evidence that proved that. All we know is that this building continues to have floods, leaks, backups, and I used to know the screenwriter of the Poseidon Adventure. The only thing that has...
I'm sorry, Mr. Davis, that's your allotted time.
I think I'm satisfied, and I've read Mr. David's letters, so I, for one, am satisfied to go ahead and move ahead.
Yeah, thank you, Mr. David. That was really appreciate your testimony. Okay, so it is time to move on. Let's see. So we had another tenant, I believe, who wanted to make themselves available to address questions. Lauren Greenfield. Does anybody have any questions they would like to ask Mr. Greenfield? Okay. I don't believe we have any questions for Mr. Greenfield. So our final speaker is Ms. Tiffany Trong, attorney for the owner appellant. Is Ms. Trong in the queue?
Yes. Ms. Trong, you will have 13 minutes to address the board. You have been unmuted. Please go ahead.
Good evening. Good evening. Can you hear me?
Yes, we can.
All right. Thank you so much. I just wanted to speak briefly in response to the oral argument presented by the tenants tonight, and then I'll move on with regard to the owner's appeal. So with regard to the presentation made by Mr. Chan and Mr. Davids tonight, it has been a common theme throughout the original hearings and also on appeal that they do make generalized allegations about violations of laws or areas of what they allege are certain construction issues, such as what Mr. Davids had referred to as far as the plumbing. However, they have failed to meet their burden of proof as specified by the hearing officer throughout her very detailed decision, in that they have not provided actual admissible evidence on several of these allegations that are frankly very complex issues, such as ADA laws or areas that do require expert witness testimony or other qualified experts to really make a determination on or to comment on, such as asbestos issues or such as, what a plumbing system is like in a building and what it can and cannot take. So, the hearing officer had properly denied those decreases for those allegations, and the record is very clear why. So I do urge the board to follow her original decision on those issues. Turning to the owner's appeal, I do respectfully request that the board reconsider the hearing officer's decision. Throughout the hearings, it was very clear that the prior owners of the building, the Sinke's family, had ignored several issues that did require serious maintenance or repair. During the 22 hearings and testimony from the petitioners, some of the petitioners themselves acknowledged these issues. However, the prior owners suffered seemingly little to no consequences at all for allowing the property to basically fall into disrepair with deferred maintenance and in some instances just outright neglect. When my clients took over the building, they dedicated significant resources into repairing and addressing these issues. Nevertheless, they are now faced with what is essentially being penalized over $600,000 for taking the burden of performing the work to repair and improve the property on top of the resources that they had spent in performing the repairs in the first place. Frankly, it's simple in hindsight now, sitting here, all of us years later, to say they should have done this differently. However, construction projects, whether they're on a small or large scale, unfortunately do tend to be much more complex than they do appear on paper. Although it's not the intent of the hearing officer's decision or the board to discourage landlords from maintaining their properties and taking care of their rental properties, the fact of the matter is that decisions like this can and will disincentivize landlords from taking the steps that are needed to consistently maintain and repair their buildings. This is not good for public policy, nor is it going to benefit tenants in the long run. So in summary, I do strongly urge the board to reconsider the hearing officer's decision and keep in mind the potentially long-term and larger impact that this could have on both the city and on tenants in the long run. Thank you.
I have a question for Ms. Trong. Thank you. You indicated that there was all this deferred maintenance and all these problems when the current owners bought the building. Were they, before they purchased the building, did they do their due diligence? Were they aware of what they were getting into in terms of the state of the building at the time, or was it kind of a surprise to them that there was all this kind of repair and remodeling that needed to be done?
So I recall it, forgive me, my recollection's not the best since it has been about 3 years. I do recall there was a detailed report. It was called the Marks or Kubo report that was submitted into evidence. However, I don't know if that report was done before or after the purchase of the building.
I believe Commissioner Chirozis has a question.
Yeah, so I just want to reiterate, thank you for coming, Ms. Trong. Is it your client's position that the appellants here are entitled to no rent decreases whatsoever?
No, it's our position that they should have at least a lower amount of rent decreases. Sorry, it's like a double negative. We do understand after reviewing, sorry, go on.
No, go ahead.
They do understand after reviewing the hearing officer's decision that, in hindsight, there were things that could have been improved or perhaps done better. So it's not our position that zero reduction should be given, but there should be a more, in our opinion, reasonable reduction awarded to the tenants.
And what is that more reasonable reduction, in your opinion?
Frankly, it's hard to say for me, frankly, just because there's so many of them and it's a very detailed and technical calculation that's presented by the hearing officer.
Okay, no further questions. It looks like Commissioner Duran has a question.
Commissioner Duran.
Yes, I do, for Ms. Trump. So you're saying that there should be a decrease in the amount of rent that is decreased, but you don't have the specifics as to which and how much each of the amounts should be reduced, I guess this is your oral argument. I mean, I don't know what would you have us reduce and what. Otherwise, if you're leaving it to us to decide, then I mean that's what we'll decide. But this is your opportunity to tell us specifically where and why and which changes should be made to the decision. You can respond.
I'm sorry,
if you have
can you
a
hear me
response.
now?
Yes.
I'm sorry. I do believe that the board should reevaluate this section specifically as far as management of the construction itself. We did submit into evidence several notices with updates about construction going on throughout the process. And my clients did make the effort to provide the tenants as much communications as they could as far as what was going on, what was happening in the building throughout the whole process. And things don't always go according to plan. Unfortunately, it's a fact of life and unfortunately construction projects. But I do believe that my client did at least do their best under the circumstances to go and meet the needs of the tenants and find, when needed, sometimes creative ways to go and help them through things, such as creating a separate storage area for their property when they had to go and repair the balconies, for instance. I'll leave it there for you, commissioners. Thank you.
Okay.
Just, I have a question for Haka or maybe Ms. Trong here. Ms. Trong, how many buildings do your clients own?
Frankly, I don't know. I think this might be the only one, but I frankly am not aware.
Okay, Haka, are you aware?
It's not in the record. I'm sorry, Commissioner.
Okay. Thank you. I don't have any questions.
I have no further questions. Thank you.
Thank you so much, Ms. Trong. Okay. Are we begin deliberation? Fellow commissioners?
Is that the conclusion of the speakers? No more speakers?
Yes, that was our last speaker. Okay, Commissioner Trosis. Foster.
I know, we're quite interchangeable, me and Carolyn.
Exactly the same hair color, everything.
Whole city just thinks we're the same person. And that's very flattering to me. I appreciate that. Where to begin? First, for the public record, I'd like to state that as an elected commissioner, you are often approached by people in the community who have complaints that fall under your purview. They come to you, they give you some detail as to what's going on, in this case in their apartment usually, and ask us for advice or ask us what they should do. Our job in that circumstance is to refer them usually to our staff and other appropriate city and civic organizations for help and assistance. And in this case, I stumbled into this building in 2016, serving Meals on Wheels. And I won't go into the details because I was advised probably not the greatest idea at this time. To stick to the things that are in the record. However, 6 years of ongoing construction is a nightmare and an interruption to quiet enjoyment that I can barely wrap my head around. We have had other cases before this group, before this commission, similar in tone, similar in content, similar in nature, but never even quite to this unbelievably high threshold of pain, physical pain, emotional pain, mental pain that people were paying to endure throughout the entirety of it, for the most part. The only relief we can give, which is not relief, it's simply a reduction for housing services that were denied during the time examined, are certainly not enough. And I certainly hope these tenants and the rest who either dropped their cases or didn't proceed with the appeal avail themselves of every city service and even private actions that they're probably entitled to pursue. I hope they do. But what I will say is, for our purposes tonight, the members of this commission are well aware that we are constrained by the ability to reduce rent by certain percentages laid out and prescribed in our charter, and that those cannot exceed 100%. I kept noting that throughout the staff report, we were being reminded that even though the percentage is 10 to 75 for this one, it was awarded 20, because the hearing officer had the incredibly difficult job of collating all of these complaints together and cobbling them together in a way that is equivalent to no more than 100%. However, the very first thought that occurred to me, and I hope it will occur to other commissioners if they agree, is that while you may not be able to exceed 100% in a day or in a month, there were many, many spots, I think, for improvement in duration. So if an impact was considered to be the exact number of days this tenant experienced this, or the exact number of days that tenant experienced that, I would put forth that we could take into consideration, I'm going to grab my power cord from my computer. Sorry, I don't lose you all. I would put forth into consideration the duration and the frequency of these terrible, terrible acts. And what I mean is, if the water's off one day and is back on the next, but's off half the day after that, and then back on in the evening, but then back off in the morning, I understand that the hearing officer has to use a mathematical application of the number of hours or the number of days. But the absolute uncertainty of the most basic services of your unit being water, being electricity, being access, to me warrants a broader interpretation of impact or reduction in housing services in a concrete way. It's not just the exact hour of the exact day when you don't know when you can return to the unit, when you're not certain if it's going to happen again the next day. Being able to have quiet enjoyment may be outside of our scope for being able to give a rent reduction for, but a housing service is access. And if you don't have the functions of a livable unit, meaning electricity, water, heat, air conditioning, you don't have access. And it's not a livable condition. We've discussed construction-related, where we discuss overall impact as opposed to hour-by-hour impact. And I believe this falls squarely under that argument. And I think we should remand portions of this back to the hearings department and grant some of these appeals to further the scope of the award of decreases. I do understand the constraint of the amount, but not the longevity, not the duration. I believe we could find more for these tenants to reflect the true reduction in housing services that I believe they've experienced. I'll hold there for now and come back after everyone else has had.
Can I just ask a question? Sorry, Steve, I know your hand was up first. For Anastasia. So are you saying that you think that there was a clear error made in the decision by the hearing officer? Because that's the standard.
Yes, I understand. Yeah, so I'll say, I'll use the phrase error in that I think the mathematical calculation of an award of a decrease should have been higher.
Okay.
Commissioner Duran?
Thank you. I think that what I'm going to say is a little long-winded, so y'all stay with me. But I think it dovetails right into what Commissioner Foster was saying, and then I'll end it with a question. So as you all know, we are held to the standard of review, and that we have, right, which is clear error. And I'll remind the listening audience, if you'll indulge me for a minute so that it's all front and center. Let's see, the standard for review, let's see here. In light of the record, there is clear evidence of error alleged in the appeal, and if the decision is reasonably supported by the record, the board should affirm the decision, even if it would have reached a different conclusion than the hearing officer were to have found as the trier of fact. All right, so was there a clear error is our first job, right? So this is what I would argue, and this is what's going to require jumping along a little bit. I'll begin by saying that I feel it's a slippery slope to allow the hearing officer to make what I call, okay, and I don't, just to give it a label, arbitrary decisions in terms of the amount that the deduction should be. And I understand why the hearing officer did it, right? Because they're capped at 100%. Okay, but I think that they have to stick with what the regulation says. So, for example, on pages 5 and 6, regarding the pool courtyard work in the fourth segment, there was a percentage range that the regulations state, and then there was a percentage that was below the low range that the regulations state. So let me get to that here, that the hearing officer gave. The range is, let me see, she gave decrease, okay, it's on page 6, first full paragraph. She gave decreases of 2 to 20% when the authorized range was 10 to 50%. Okay, now I understand why she made that, because she can only go up to 100%, but I think that he or she, I don't know who it was exactly who did it, but went below that and they couldn't. So that's one example where it went outside the range that were prescribed to give. The second area, and I just do this for the record so you can track along later, was the recurring water shutoffs on page 7. Again, there were an allocation given that was outside the range. On page 9, the hallway renovations, another amount that was given. The balcony railing, which actually went too high, went above the range, okay, than what the regulations provide. The reduced parking access on page 12. The security issues on page 14. Work outside of permitted hours on page 15. And the elevator use by construction workers on page 15. Okay, so my feelings are that if we allow this, if we affirm this decision, it's going to set a precedent where there's a slippery slope with not having to follow the regulations as written. And so my recommendation would be to remand to have these totals increase where they should be increased so that they're in the regulation range, or decrease where they need to be decreased if they've extended beyond. And I understand that there's the 100% limit. Maybe that's where, on the remand, Commissioner Foster's idea comes into play that extends the duration, if we're allowed to do it, to compensate in time, as opposed to, so it's still 100%, but it's 100% instead of doing it for 8 months, maybe it translates to 100% for 10 months to compensate for that difference. So that's my thought. And my last point that I want to raise is I am moved by Mr. Chan's argument on his reply. And I want to ask this question, assuming that his argument as to our regulation regarding A, B, or C and the exemptions thereof is followed, okay? My question is, even if an error was made by the hearing officer on the way they applied that regulation, was it a harmless error? And that's legal jargon, right? I mean, none of this is harmless, but in legal jargon, was it a harmless error because the damages that we could allocate are maxed out at 100%? So even if we put aside his argument, they're still getting, for many, many months, 100% of their rent reduced, which is the maximum amount we can do it based on all these violations that have been committed. So to summarize, even though he makes valid points, in light of the decision and my suggestion that this be remanded to calculate the damages within the parameters that the regulations set, wouldn't his reply be harmless error because they're going to get 100% of a rent reduction? So
Chair, may I?
Any questions about all that?
Please.
It's a lot.
Yeah, can we get Haka to tell us if that's like a correct interpretation?
If I may, I will respond to two separate points that Commissioner Duran raised. The first is that Commissioner Duran, you raised, I believe you couched it as ad hoc, going below the range. That is actually not ad hoc. Your very regulation states that the hearing officer may go below or above so long as they provide and articulate the basis for why they went below or and above. And in each and every case in which I reviewed those for you in the staff report, I mentioned the reason for which the hearing officer went below or above a certain point. And so I want to just emphasize that this is not a slippery slope, but rather following the actual regulations that the hearing officer is supposed to follow. The second point that you raised, I believe, is if you were to completely come with a new interpretation of prong C into this situation, if that would make a difference in the reductions, I'm sure it can in certain circumstances. It's not that in every situation everybody has 100% off from the decreases on a given day or a month. The hearing officer went through each and every impact and came up with the calculations in that way. The issue with Mr. Chan's arguments, though, is that if your own regulations say that if a unit becomes uninhabitable, so if that was done because of a necessary repair that was done in a reasonable manner and in a reasonable amount of time, if it becomes uninhabitable, that there are habitability violations or nuisance level of violations that you are not allowed to give a decrease for that. So C has to be something above and beyond that. And that's why the language, and that's why I brought up the case with Golden Gateway, because contrary to what Mr. Chan said, Golden Gateway wasn't about just reduction of housing services. These people were living with construction going right outside their window that they used to go out into. Sure, they lost that balcony, but there were fumes, there were noise. Imagine a whole balcony was being replaced not only outside your unit, but the one next door. And yet the Court of Appeals said no, that it was necessary repair, and therefore they denied it. And also a point that was raised by Mr. Chan, which is incorrect, that I want to bring to your attention, is that he mentioned quiet enjoyment and how the California law provides quiet enjoyment. And he points to the hearing officer's decision, page 15. In fact, the very answer lies in that page, because that California law nuisance goes in, the quiet enjoyment goes into nuisance. And nuisance is prong A. And that means that if a unit has habitability violations or nuisance, if the work was done in a reasonable manner and in a reasonable amount of time, then you are not authorized to grant a decrease for those. And that's an important point for you to take into consideration as you make your deliberation.
Okay. Thank you, Mr. Mordesai. I think I still have the floor.
But yeah, let's let Commissioner Duran speak, because Haka was responding. Mr. Mordesai.
Yeah, thank you. Thank you, Mr. Mordesai. So I also want to make the point that I didn't disagree with any of the hearing officer's determinations as to was the evidence shown and presented at the hearings reasonable or not. So I found that there was no unreasonableness as to any of those aspects in the hearing in the report. My only question was whether or not those ranges were was it error for the hearing officers to make determinations outside those ranges. Mr. Mordesai, thank you for making that point, because I want to safeguard against there being a slippery slope. So I appreciate your clearing you're clearing that up. And then finally, I just wanted to say that I wanted to address whether the points of Mr. Chan's argument was if there was any validity to his arguments, if it moved them under remand when they relook and do calculations, which I think this may be heading to maybe not, but heading that they take into consideration whether or not it would have mattered. Mr. Mordesai says that in some instances it may have mattered as to the individuals. Then I think that should be taken into account, so long as it complies with legal precedent, of course.
If I may clarify my remarks, Chair, I didn't say that. All I was saying is that if you were to come up with a wholly different interpretation of prong C than the one that legal staff is telling you, then yes, that could make a difference, because there were things that were done that were necessary repairs that were done in a reasonable manner and in a reasonable amount of time. But if you were going to say that regardless of that fact, we're going to take a different interpretation of prong C, then of course those things would be thrown into question, right? Those would be issued. That's the only point that I was making.
Got you. And okay, so I'm glad you made that, because I'm not making that point. What I'm making is I'm not disagreeing with that interpretation of the regulation, but it seems to me at first blush that if you look at Sorry, I got a kid. How's it going? Under the requirements, it says the board may grant rent decrease under the regulation only under one or more of the following circumstances. A, the tenant petitioner's controlled rental unit is made uninhabitable by construction occurring in the property. B, construction results in a substantial reduction of a housing service, or, which means it could be either of these three. construction substantially interferes with the tenant petitioner's ability to occupy the controlled unit as a residence. So my question is, if we interpret C to mean what it's saying here is that a tenant can't be in their unit, then that's superfluous to A, because that's what A is saying. And so I don't think the construction of what was for it to be superfluous. So I'm thinking that C is actually a lower standard than A is, right? You could still be there, but because of all these other issues, it's such a substantial interference with their living, like noise, for example, like the on and off of the water, like, and some of those other examples that were given in the report. So, because what I'm hearing is that subsection A and subsection C are equal, right? Because they both require uninhabitability, but that's not what the statute says. Subsection C does not say anything about being uninhabitable, but I think the interpretation is that it's made uninhabitable because of all these reasons. And it's just saying it substantially interferes with their ability to occupy. Doesn't mean they can't occupy it. And that's why I think it's going toward what Mr. Chan's argument was in his reply. So anyway, that's the comment I wanted to make about that.
Okay. I'm not quite sure that I followed Steve's line of reasoning, but I did follow Haka's, trying to just figure out, Steve, the point you were expressly making. But I will just say that, although I haven't had intense personal involvement with the tenants of this building, all of us know about it because we've seen what's been going on. And I think that it's not, I misunderstood the rules and I didn't know what I was supposed to do and we thought we complied and we think, the 2 years of rent relief is unreasonable. I mean, this was a systematic pattern of egregious activities. And I would like to note that, we say in the staff report here that initially tenants in 24 of the units filed construction decrease petitions, and already between the period in which they were filed and when the hearings first took place, 6 people withdrew because they moved away. And so this is like the systematic pattern of harassment, as far as I'm concerned, that we see, in a lot of these redevelopments, if you will, of existing rent-controlled property. And the people who really are suffering and who are harmed are our long-term tenants. And these are the people we aim, at least the reason I'm on this board, to protect the integrity of our community, protect people who have lived here, made this their home, and give them the dignity to age in place. And Mr. Davids, I just appreciate you, and I appreciate your tenacity in living through this and staying and coming and chatting with us and letting us know, all of the different issues that are going on just for our renters in this city. So I think it was pretty apparent to me the lack of defense from our owners. I didn't hear any compelling reason to reduce any of the award in the hearing officer's decision. And I will just say, I know Steve has his hand up, so I feel like Steve is like ready to check me over here. But I will just say that when I was reading this and then looking up, the cases, I do think the Golden Gateway Center case was really kind of, I don't want to say dispositive, but that precedent was really important to me, because at first when I was reading through this, I said, how could we find that the tenants were not entitled to additional decreases because they weren't able to live in their unit? But if you look at the standard set forth, in Golden Gateway Center, I think that it's an extremely high standard to meet. And yes, I understand that things aren't fair and it doesn't make sense to us from a plain language standpoint, but I think we have to look at what kind of precedent has been set. And I think that, to me, the landlord was undertaking necessary repairs. The only issue outstanding for me now is this air conditioning situation for Mr. Davids, that would be something that I would be so first of all, I will just say, just very transparently, I generally speaking want to uphold the hearing officer's decision because I don't think that there was a clear error made here. However, the only item that I think warrants potential a remand is this issue with the multiple air conditioning units that are still to this day detracting and not allowing Mr. Davids to literally live in his apartment. That's kind of the one issue that stuck out for me. So I will defer to Commissioner Vice Chair Duran, and I know Chair Sultan hasn't commented yet, but that's where I'm headed here.
If I may, I just wanted to make clear that well, you said that you weren't sure about what I was trying to say, and I think I know what I'm trying to say is that the reading that Mr. Chan has of this regulation, I think, allows for a more expansive a more expansive area where rent reductions can happen, because you don't have to be forced to move out before you're able to get a rent deduction, so long as you can show that it's substantially interfered. So I just want to make sure that I'm kind of agreeing that I think more of a deduction should take place. And so the remand, if there is one, if one is voted, would be to figure out how you increase where it's appropriate the reduction, whether it be more time, whether, something. That's why I'm suggesting a remand based on my arguments. I'm sorry if it wasn't more clear, but that's the point I hope that I've conveyed to my fellow commissioners.
Okay, can I ask a question? What would be the consequence? So there were those multiple instances where the hearing officer said, well, the guidelines are 10 to 50%, but we're going to go with 5% because, when you add everything together, it's getting pretty close to 100%. What would be the consequence of, sort of remanding or, let's say, raising that amount? What impact would that have on the tenants?
I mean, it depends. As you can imagine, this is such a complicated case because not every tenant claimed things, right? So it also has to follow what tenants actually claimed. All tenants may have suffered from those things, but you can't give awards for things that they didn't claim. So it really depends on the specific the specific case, the specific situation. For example, you had mentioned water shutoffs, right? Well, not every tenant got a water shutoff, even though presumably everybody dealt with water shutoffs, but although that's not necessarily clear. But when water shutoffs were given, it wasn't given by the hour, Commissioner Foster. It was given by specific days in which the water was shut off. The whole day that was given as for the decrease for that situation. I just wanted to mention that point for that. Also, Commissioner Terrosis, with regards to the condensers, that's really a regular decrease petition. Because what it apparently is being stated is that there was a housing service that was removed, and as a result of, it was removed from there, and so it's not necessarily ongoing as a result of it. It's not like noise or dust or things like that happened because of construction. These things were reassembled with permits, but they were reassembled in some way that the tenant is alleging is depriving him of housing services that he used to have. It is more akin to a regular decrease as opposed to something that's in the construction decrease scenario. And they're and it often can result in greater decreases than would necessarily be involved in a construction decrease situation.
Wait, really quick. So are you saying, Mr. Mordezai, that because this is an ongoing problem in a housing service, in a reduction in housing services, that if one feels that that's happening, that they should file a regular rent decrease petition and can do so?
That they certainly can, right? Because that is what a construction, and that is what a regular decrease petition is, right? Because a regular decrease petition is an ongoing problem that hasn't been cared.
Okay.
And
Separate from like the deadbolt, right? They lost the deadbolts during the construction, and now they have that ongoing, what if $5 per month reduction of rent.
yeah, I mean, there's like gray areas, right? Like where the things, but for example, the deadbolt, they got the deadbolt because of there was an actual reduction as a result of this construction that occurred. I'm just offering that as another possibility that's available in this situation with regards to the condensers, and then there would be an opportunity to provide evidence about that wasn't necessarily provided in this context.
And then just to follow up on so if they were to go back and say raise some of those percentages that had been lowered due to the kind of overall construction impacts approaching 100%, would that mean that these rent decreases would extend for longer? Like they would,
yes.
Is that what we're talking about? Okay, so it could potentially be more than the 20 to 25 months or whatever we have.
Correct. It depends on each case, but certainly that's a reasonable assumption.
Okay, and you're saying that the tenant with the condensers could absolutely file a separate reduction of services?
If I may ask Ms. Nalaboff if I'm incorrect about what I'm stating, or if in fact maybe there's an ongoing case involving that.
I'm sorry, an ongoing case involving what?
The issue with the condensers, wouldn't the tenant be able to file a regular decrease since it's an ongoing issue, would they be able to file a regular decrease petition for the intrusion of the condensers into their
sleep? Yeah.
Yes. I mean, he could file a regular decrease, or I understand the main impact he's claiming is noise. So he could claim that. There's no guarantee what would happen, but yes, he could file a decrease petition on the condenser issue. I agree with you that it was not really a construction-related impact, the way that this reg anticipates.
Sorry. In that case, I retract my previous statement that Mr. Morzai, thanks for explaining that, and I would be here to affirm the hearing officer's decision. Sorry.
Commissioner Foster?
Thank you, Chair. I also had a lot of concerns about the set of condensers being moved, but it sounds like there's another course of action for that I'm sure staff will help discuss with Mr. Davids at an appropriate time if that's a path he chooses to go down. I have a question, because now we just got done saying that, because I don't want to let this go yet. If we were to remand and ask hearing staff to further explore impacts in volume and length, not in percentage, these people who wrote letters one by one saying that they agreed with Mr. Chan's letter, you're saying that they should have applied for appeals for their own specific problems in defense of their appeals, or in support of their appeals. And I think they might think they did by jumping onto Mr. Chan's letter with their own formal letters saying that. Do you think there's any confusion here?
No, Commissioner, that's not what I was saying, if I may clarify. All I was saying is that the hearing officer granted decreases based on what the tenants actually alleged in their own petition, not in their appeal. So it had nothing to do with Mr. Chan and his appeal. That wasn't my point at all. My point was some people didn't ask for a decrease in water shutoff in their initial petition. So the hearing officer can't give it to them. They didn't ask for it. Just that. It's a factual issue that I'm just pointing out the complexity of this case. Yeah.
Got it. Yep. Thank you for that.
Mhm.
So, yeah, thank you. That being said, I think that would bolster my argument that a remand should take place, because, again, the amounts allocated in many instances were below what the range would be, and in that one instance above what the range would be. And the mindset of the hearing examiner was, I can only get to 100%. So that's why I'm going to decrease across the board for all of these appellants the amount that we will decrease their amount by. But based on what I just heard, it sounds like some of them didn't file complaints on all the things. So they may not be at 100%, but what they can get their rent decreased is going to be locked in based on what we rule on this appeal. So in those individual instances, I think that the rent reduction should certainly be raised to be within the range. And a hearing examiner would have to re-examine those to see if, where that should fall in relation to their own claim. So just to be clear, and that it sounds like in the instance where 2% is allocated, I wouldn't want that 2% to be allocated across the board if all of them are going to be stuck with 2% when maybe they wouldn't have to be because they didn't raise the claims.
Commissioner Duran, if I may interject, it's not that the hearing officer took a look in every situation and said, you only get 2% because if I add it up, then you're going to get, I have to balance all the other decreases as well. It's that sometimes the decrease that's in the regulation is for a certain thing that is analogous, but it's like, for example, but it doesn't. But what's actually occurring here is of a minor nature compared to that. Not minor, but lower nature compared to that. And so it doesn't rise to the level of a 10% reduction. And there are those circumstances as well. So I just wanted to make that point.
Okay, but I will say that there are several times in where there does appear to be a reduction below the range based on, as described in the staff report, consideration of other construction impacts, which I think means, right, that they were already kind of experiencing all this hardship, from other sources. So we're kind of going to count this one maybe not as significantly if we would, if they didn't have this other problem also being imposed upon them, which, I think the logic of that, I see the merit in kind of questioning the logic of that approach. And I do think it's distinguished from the one that I remember where the hearing officer went over the range was the one with the balcony, where this person had a giant balcony that was this huge amount of the square footage of their apartment, and they couldn't use it at all. And it was also I believe dust and just intrusion from the balcony into the unit itself. So that seemed meritorious. That seemed that it was based on the actual circumstances that person was experiencing on that, based on that particular construction impact, versus the other ones that were below the range that appeared to be more based on a desire to, I don't know exactly what it is, right? But to not.
I agree. I think, Naomi, can I offer?
Yes. I was fading.
It appears that that the first and total goal was to keep under the 100% figure in total, which we have to do. However, a completely different way to make, honestly, to to remand and ask for more is that not as on a basis of percentage or per month, but the much longer uncertainty and in some cases uninhabitability, in some cases lack of quiet enjoyment, I think those things could have been extended more hours, more days, more weeks than they were. Not that they should have. I think I understand exactly why they needed to allocate the percentages the way they did, because that's clearly within, what they had to do. But I would put to you that there could have been many more weeks granted based on impact of the decrease in these housing services that maybe were taken too literally, hour by hour, day by day, and could have been assessed a greater value in longevity. And that's what I'm asking to be studied again.
Because it sounds like they didn't, the hearing officer didn't have to, evaluate each individual construction impact in light of all the other ones, right? They could have evaluated each one independently. And if this, whatever the dust or what, if that's, merits a decrease of a certain percentage, just because something else also rises to that, you know what I mean? They're each individual impacts. And just because there's multiple doesn't mean that the individual ones are less kind of significant.
But I think what they're saying is that's the toolbox they have to work with, is the 100% figure. So if they gave 75% rent reduction for every impact, 75% of the range of dollar amounts that they're able to reduce it by, they can't go past 100% of the MAR per month. But I guess
accurate, like Mr. Is that accurate, Haka?
I'm not sure I followed what was being stated. I apologize.
I guess we're asking clarification on the 100% issue.
So, you cannot give more than 100% decrease. It's not the case that people necessarily got 100% decrease all the time. The evaluations were made based on the evidence in the record. So, for example, decreases were given for a certain item because the construction for that item occurred in a certain period of time. Or water shutoff decreases were given because that's the day in which there was evidence that showed the water was shut off. So these things were done based on the evidence that was presented. And yes, there were situations in which the range could be 10 to 75%, but for multiple impacts. But in order to not go over and to give a punitive thing of more than 100%, the hearing officer made a decision to give 20% for this, 20% for that, 15%. Those were the kind of decisions that the hearing officer did make in this in her decision.
What would have been the impact of going over 100%?
You cannot force in a construction decrease, you don't have the authority to make the landlord pay for more than what they're getting in rent. That's not something that's provided to them. And also, it's not that there was no services necessarily received, right? You were living in an apartment. So that the hearing officer weighed all of those things and made a decision based on the evidence that was in the record as to how much that was given. And the question before you is whether that was a reasonable decision given the record.
Commissioner John?
Yeah, so the question I have is, were all the tenant appellants, did the result for each of them end up being that they got 100% reduction in their rent?
No, I don't believe that that's the case at all. But that was also the point I was making, Commissioner, because when they were living in their apartment, so you get a basket of goods, right? And the basket of goods includes the walls and the whatever, everything that's involved.
Right.
And so here you're going kind of backward and saying, in that situation, what was the impact? How much of the decrease should I give? What was the range that was given? And so the hearing officer had to take all of those things into consideration and made a decision. And if it was a reasonable one, then...
Okay, I follow that. I follow that. But what's not clear in the report is how the amounts fell for each of the appellants, and how that percentage that was derived by the hearing commissioner was applied to each of the tenants. So what it looks like is that there was a number that was given, a percentage that was given, in several instances below what the regulation is, and applied across the board to all of them. That may not be what actually happened in fact, but that's what the report looks like to me. And that's the issue that I have. Perhaps if it's redone in a way that shows what the allocations were for each of the individual applicants, then we can see, it's very transparent, how that percentage translated to each of those for all their various individual factors.
That was done. Each and every decision includes a document that sets out what the decreases were. That was done by the hearing officer, and it says both percentage and the dollar amount. That's how there, and that was included in the documents that was provided in the record to you as well. Those are all, it may not have been in my staff report. I wrote a 25-page staff report, and my point was to summarize things so that you could actually get your hand around this thing that took years, right? But definitely that was done. For each and every tenant at their decision was included the percentage and the dollar amount.
Okay, so point of personal preference or whatever, the comments I'm making are for the benefit of the general public. I'm not making them to attack anybody or to question the credibility of any writers or reporters or hearing officers. I'm just trying to discuss the issues so that we as a commission can come to the best decision wherever that may fall. So if I've offended anybody with my comments, that was not intended. I am just trying to get to a very difficult issue that's taken many years. It has many, many different faces, many different reports, and trying to make it all as transparent and forthright as I can. So thank you for answering those questions. Yeah, and we'll see where it goes if there's more deliberation.
I'm prepared to approve the hearing officer's decision. Clearly, there are things that we might have done differently if we had been the hearing officer. But the standard is clear error. And, based on what I read, based on what Haka said, I'm not seeing the clear error. I mean, there was so much work put into this over a period of so many years. And it's, like Commissioner Foster was saying, I mean, these tenants endured, unimaginable conditions. It sounds like they may still be going on for 6 years at least. And I do believe that there is some measure of justice, provided under the charter, under our regulations, by providing them the rent, decreases that the hearing officer ordered. So I am prepared to support that decision. Commissioner Trosas?
I'll second that, and I'll just say that I was impressed by the thorough nature by which this was approached. And again, while we might disagree on a few things, it's not about do I disagree, it's about was there an error, and I did not see an error made. And thank you for the clarification on the rent decrease petition on the one item, and so therefore I'm prepared to second that motion, and I think we should vote.
Commissioner Foster?
So I just wanted to say before we vote that I am hesitantly persuaded by Commissioner Grosses and Chair Sultan. I saw, I saw a type of error that I still consider to be room for that argument, but I don't think I see a consensus heading that way. So I'd rather be unified and take care of this. And I agree, our staff outdid themselves. This is a Herculean effort and the largest lift that our agency has ever had, I've been told, in a scope of a hearing. And that is through a pandemic, that is through staff changes, that is through, unbelievable circumstances. And it's not that, anyone thinks staff didn't do it right or didn't work hard enough. It's that these tenants endured such unimaginable hardship. And it's a shame that our law doesn't allow for broader and more thorough remedies.
I think that's the key. They can avail themselves of a different
I sure hope they do. And after we vote, I'd just like to make another comment after we vote, please.
Commissioner Drawn?
Steve?
You're muted.
There we go. I couldn't hit the right spot on my computer. So I agree with Commissioner Foster and all that's been said about the hard work, what the staff presented, how thorough it was. 100%. I don't feel that this was an easy lift by any means, and it was a job well done. At the end of the day, I feel that we could have done a little more with a remand. But I don't want to just, I don't want to say, I also agree, and I'll restate it, that the staff did a great job. This was a very hard case, and I get it. So anyway, whenever you guys want to call the vote, I'm ready to vote.
Can we take a vote?
Yes. Commissioner Foster.
Yes.
Commissioner Trosas.
Yes.
Vice Chair Duran.
For the reasons I've stated, my vote is no.
Chair Sultan.
Yes.
Motion carries.
Madam Chair, may I say something?
Yes, please.
In September of 2016, we couldn't find our client, Meals on Wheels, a very elderly woman, and she's the woman Mr. Davids referred to as a partial amputee and multiple disabilities. She had several adaptive devices in her apartment, had lived there for 38 years at that time. I found this woman 9 hours into the day in an empty apartment that had no electricity, no hot water. She had no cell phone. She was in her late 80s and incredibly handicapped, and was lumped onto a love seat in a darkening room in winter with no water and no food and no means of communication and no idea when anyone was going to come back and get her. or if they ever were. She experienced such distress that she encountered intestinal issues, and the callous disregard for the tenant's safety, the tenant's quiet enjoyment, are only personified to me in the case of my friend, who's no longer with us. This building has been cited for advertising furnished units. The tenants of this building have suffered unbelievable hardship. I witnessed it myself. I stepped over construction material attempting to deliver meals. I shared elevators with pallets of cement bags where I barely could squeeze in. I saw this unfold. And then when the petition started to be filed, I stepped away, as is my duty, so as to be able to remain neutral and hear this case in appeal if it were ever to come to us. But this city values its renters. This city values its housing stock. It does, and reasonable attempts to make repairs in ways that do not unreasonably burden our tenants. Of course we care about their safety. Of course we want buildings improved in a reasonable fashion. And that's what this board exists to do, is to regulate the rents that are paid in exchange for housing services. I know that the tenants didn't all get what they wanted tonight. I'm sorry for that. But there are paths available to tenants in this city, both through the city, the rent board, and through nonprofit organizations. And I implore every one of you to lift up those phones and call until you're heard. And find us, find organizations, and we are here for you. We can get results when it's warranted. And I have very strong feelings about this case, and I just wanted to say a few words. I don't usually do that, but I wanted to. So thank you for entertaining that, Chair.
Thank you, Commissioner Foster. That was, it just reminds us how important the work that we do here is. It feels so technical sometimes when we get these reports and percentages and whatever, all these different housing amenities. But it's like people's actual lives are hanging in the balance. And so thank you for sort of reminding us what's at stake here. Okay, I believe it is time for us to adjourn. Don't believe we have any further business. And the tradition is to take a vote on adjournment.
I'll move to adjourn.
Right, start with that. I will second that. And then no.
Commissioner Toroses.
Yes.
Commissioner Foster.
Yes.
Vice Chair Duran.
Yes.
And Chair Sultan.
Yes.
Motion carries.
And I just want to thank the staff, if I could, for a minute. I know this has been really, really hard. And, Naomi says the work that we do here is so important. Well, this is not our full-time job, but it is yours. And the work that you do is really important. We really, really appreciate you. So I just wanted to say that. And thank you for all the tenants who spoke up in this case. I'm sure it was not easy. Bye.
Good evening,
Thank you,
Commissioners.
everyone.
Have a good night.
Thank you.
Bye.
Good night.
Thank you.